Okay, welcome to Chapter 12. We're moving into probation, parole, and intermediate sanctions. Some students ask me why we start off with talking about probation when we're talking about correction. And the simple answer for that is that probation, parole to some extent, and certainly intermediate sanctions is the dominant way in which in this country we handle most post-conviction behavior. So prison, even though it's very common in the United States, far more common than in many other countries, is not the immediate answer. Probation very typically is. And we'll look at some of the numbers and that'll be a little bit clearer. But that's because of its scale, that's why we really go in and talk about it. Some questions, of course, and I always post these questions before. If you think about the last chapter where we talked about punishment, and rehabilitation as at least two, and then there's specific performance as well, and a few others. Does probation really qualify as an explanation to the punishment query I asked? Why do we have punishment after conviction? And if it doesn't, what is the purpose of probation? How is probation different than incarceration or different than the death penalty, besides the obvious mechanics? Next question, what crimes deserve probation and which crimes deserve incarceration? What is the standard to distinguish the two? Why do you say, okay, this crime, pick a very heinous crime like rape, this crime deserves actual incarceration. Pick another crime like fraud, which frequently results in probation. Why? Does probation widen the net? That's a term I've used a couple times in these lectures, but basically the idea that the more you focus on something, the more of it you find. And I guess one of the phrases I'm sure you all are sick of hearing is if you look for crime, you'll find it. The idea that by having the alternative probation, you can have more crime that you can punish. If you had to if your only option was to lock people up convicted of crime, that would limit the number of people you could prosecute because there's a limited number of jail cells. That'll be a little bit clearer as we go on. Final point here is if parole was abolished in your jurisdiction, and in many places it is largely gone, it's certainly gone at the federal level, why did we get rid of parole? Why did we change? Again, these are learning objectives overall for the chapters, not anything critical you need to look at here, certainly. Okay, so to start off, probation today is by far the most common thing that happens after you get convicted of a crime. There are about nearly 4 million people, 3.8 million offenders, who are serving their sentences for their convictions outside of prison, outside of jail, on probation. And then we can add in another 800,000 or so, 850,000 or so. And again, all these numbers have been rounded to make them easy to remember. They're really ballpark numbers. These are going to vary year to year. So if I gave a number here that was precise, if I said, 867,391, that number is only good for this year or this month or this data. And then there would be some confusion about what was and wasn't included. So I give more general numbers that certainly are not trying to trick you. I'm trying to give you just these ballpark numbers. Okay, so there's about 850,000 that have gone into prison, served some of their time in prison, and now are out. Remember, the difference between probation is you never go to prison in the first place. We put you on probation. Parole is you go to prison, but then we let you out from the prison to finish your sentence. Of course, parole and probation are called generally, when we lump them together, community corrections, and they're often considered a less severe option, less punishment, I would say, than actual incarceration. Okay, so why do we have them? Well, here are some of the suggestions, and again, you're probably sick of hearing of this. Well, when someone gives you a list, here's the reason for this, 1, 2, 3, think about, are there other reasons? Don't just accept what I tell you blindly. I'm giving you some of the best information I have. It may not be as complete. You may need to go out and think about this on your own and say, well, what about this? And investigate that. That's part of what college is about. So having said that, what are some of the obvious reasons why we have it? Well, reintegration. If someone has been convicted of a crime, usually they will have been in jail pending their arrest. They might have been in bond. They might have some restrictions. Probation, community corrections allows them to be reintegrated into the community. Remember, everybody, with very few exceptions, is going to get out of prison or jail someday. And you've got to bring them back into the society. You've got to make them functioning members of society. And it's easier to do that when someone's on probation than from the jail cell itself. Diversion. One of the things that I did when I had juvenile clients in North Carolina was I tried to get them juvenile or felony diversion. You don't want to have a criminal record for a juvenile. It could dramatically affect his opportunities later in life. So you want to divert them away from prison and jail and towards these community-based sanctions, because sometimes it's just seen as a better fit. And then I think the thing that sometimes gets overlooked is it's cheap. If a jail cell costs $50,000 a year or $30,000 a year on average, I guess, maximum security can cost more, minimum security can cost less. If it costs you $30,000 a year to put one inmate in jail, and a probation officer can watch 200 inmates, well, trust me, you're not paying that probation officer $600,000. So if you're not paying him $600,000, 200 times 30, okay, 200 times 30,000, if you will. Oh, wait a minute, 200 would be, if it's 10,000 each, that'd be 2 million. Oh, I'm sorry, it's 6 million. So you're saving a lot of money. As soon as you have more than, say, 10 people that a correction officer is handling and not a jail cell is handling, it surely pays for itself. So community-based corrections is a good financial alternative. Also, sometimes you have a negative that's turned to a positive. If you have someone in jail, he's not earning any money, he's costing you money. You're paying for the jail cell, you're paying for his medical, you're paying for his food. But if he's out, and if one of the conditions of his probation is he has to have a job, well, then he is contributing financially to society as opposed to costing society money. Of course, this low-cost alternative is a economic, not a criminological reason, which doesn't mean it's any less valid. A person on probation is not a full citizen. They don't have the same rights as you or I. So first of all, they are typically under the supervision of a probation officer or the courts. If it's a very minor crime, it may be unsupervised probation. Again, the theory is we can do this more economically, more humanely. In practice, of course, a lot of these prohibitions can be quite severe, quite difficult to live up to, which is why, sadly, some people fail or have their probation revoked. So here's a quick chart, just to give you an idea what happens about the sentencing. So you can see there that more than 50% of people are on probation. A small percentage of people are in jails, and parole approximately equal, and then there's state prisons. Federal prisons very small, and then you've got Indian county jails, country jails, immigration, military. Those are all very small. But by far, if you look at that chart, the largest single result of a conviction is probation. Okay, when don't people get probation? What can really result in probation being denied? Well, certainly if someone was accused or arrested, probable cause was found that they had committed multiple charges. So if you have someone that committed one hit and run, yeah, the odds are that they might get probation pending trial. If, on the other hand, they committed 10 hit and runs, they're not going to get a probation charge. If someone commits a crime while they're already on probation parole, so you were in a traffic accident where there was property damage, you left the scene of the crime, you were placed on probation for this, now you committed the same offense again. The odds are you're not going to get probation again. If you have prior convictions in the past, if you're addicted to narcotics, if you seriously kill or injure a victim, so if instead of this hit and run it's property damage, you actually ran over a child or you ran over some victim, then the odds are you're not getting probation. And use of weapon can trigger longer periods of time. And sometimes this is built in statutorily, and I can talk a little bit about this in North Carolina. We have a 60-month or a 5-year sentencing enhancement if you use a gun. So using guns really ups the ante quite a bit. So who gets probation? And this chart's a little bit confusing, to be honest with you. If you look at the state population there, you'll notice that the state population, and this is Texas, it's about 45% white, and it's about 33% our prison and jail populations. And you can see how there is a difference in who's in jail and who isn't. And then if you look at who's on parole, you'll notice that even though whites, who are 45% of the population, but 33% of those who are in jail, they're 56% of those on probation. So whites are far more likely to wind up, in Texas at least, on probation. If you'll look at the chart for African Americans, or what's classified here as black, they are 12% of the population. They're 32% of the people in prison, and 25% of those on probation. Again, if these numbers all tracked accurately, and if there was clearly no systemic racism, I'm not saying there is, but this is an example, this is a factual argument is, then you would expect that yes, African Americans or blacks are 12% of the population, 12% of those in prison, and 12% of those on probation. But they're not, obviously. Moving on, sentencing and probation. There are different options with probation. We can talk, and I'm going to jump ahead and talk a little bit about shock incarceration here, which is both a option, but you can give people limited times in jail and then let them out right away. Now that kind of looks more like parole, actually. But one of the things we've learned when we've studied the impact of jail psychologically on an offender, particularly a first-time offender, is that whatever good jail does psychologically, jail and prison, it does early on. So there's the realization, my God, I really messed up this time. I'm in prison. This is really bad. And I need to change my life. That type of epiphany doesn't happen 6 years into a sentence. It happens 6 weeks in. What happens after that is the socialization process, whereby you take a civilian and you turn him into a convict. That doesn't happen the day he walks in the jail cell. That takes a period of time. So if you can give them the strong incentive not to reoffend, and then let them out before they go through the process of becoming a convict, you're getting the best of both worlds. Now, we also have options like intermediate incarceration, and you'll see these sometimes very creatively for drunk driving charges, where you'll say, okay, you've got a job, you're supporting your family, we don't want to put you in prison, but we want to have some level of punishment beyond simple probation. So your weekends are going to be spent in jail. It's an option. What are classic conditions of probation? What typically is required? Well, obviously there is usually reporting to a probation officer, paying court costs and restitution, and that also very frequently includes paying the ongoing cost of your probation, and it can include the cost of paying electronic monitoring. Here's a big one that is somewhat contentious: getting drug or alcohol treatment. This can be a requirement. It often is if you're getting probation for a drug offense or an alcoholic-related offense. The problem here is this can be expensive and difficult to find. If you're in a county, there may be no drug and alcohol treatment programs in a rural county. You may have to go some distance. You may have to pay some money, and you may not have that money, which brings up the next: maintain a job. Again, this can constitute a real change of location. You can wind up having to move from where you are because the condition of your probation is you've got to get a job. You don't have a choice. Okay, so maintaining a job can be a little bit more complex than you might originally think. First of all, it may compel you to move from locations, often rural locations where there are few to no jobs you can get, to urban. So this can, to some extent, transfer crime, possibly, from rural to urban locations or from locations of low employment to locations of high employment. Obviously, one of the conditions you'll see is don't commit any new crimes. As I said, if you commit a new crime, you're likely to lose probation. Don't associate with criminals. Again, sometimes this can be difficult if people you are in relationships with or people that you know have criminal histories. Often there's curfew requirements. And there can be additional. These are just some of the most common ones that you're going to see. Okay, so a judge in imposing conditions of probation has a tremendous amount of power. Um, if it's going to be probation, now the length of probation, that may be more set, but the conditions of probation can be pretty much tailored. And a lot of this has to do with what the judge is focusing on. If the judge is thinking, well, this person is the sole support of their family, then he might be more interested in preserving the family or preserving his ability or her ability to work to support the family than in punishment. And conversely, you can have someone that says, well, I really don't care. Punishment here is important, or treatment is important. You can see the conditions of probation much like a contract. If you violate the conditions, if you break the contract, you live with the results of that breach of contract, in this case, jail. So I talked about some of these standard conditions, the ones I just went through. And like I said, they have some routine ones that you would easily understand, keeping a job, not committing more crimes, reporting to your officer. Also, there's some technical administrative ones like notifying any agency of change of address. Then there can be punitive ones. Again, this can be designed really to punish the individual. So suppose you had someone convicted of drunk driving. You might say, okay, I want you to surrender your license, or I want you only to drive. This is a very common condition of alternative sentencing for drunk driving is you get what we call Cinderella licenses. You can drive during the day from this hour to this hour, to and from work, that's it. So we're going to punish you by not giving you the full freedom to, basically drive and endanger other people's lives. Then there's treatment conditions. At the root cause of many of society's problems is the addictive nature of the human animal. We are addicted to all sorts of things. We can be addicted to relatively minor things like myself, like coffee. I have to have my cup of coffee in the morning. Doesn't have a lot of negative side effects, but it is kind of an addiction. And these can be very, very mild psychological addictions. They can be a little bit endangering. We can be addicted, and some of us are, to sugars and fats. And then we can up the ante here to something where it becomes a physiological, where your body craves it more, and this can get very dangerous. This can move from the point of an inconvenience or a health issue to a survival issue. And this could be things like addiction to alcohol, addiction to opiates. So very often we have treatment as part of the conditions for probation. And this is to help you with any issues that might contribute to criminal activity, because there is a link between drug abuse, alcohol abuse, mental health issues. So we may say, well, look, you have a drug problem, you have an alcohol problem, so we want you to go for, first of all, a evaluation. When I do or did drunk driving cases for clients, one of the things that I did before they ever walked into the courtroom was I went and had them do a drug and alcohol assessment. That was going to be ordered anyway, and if I did it before, because it was going to be part of their probation if they got probation. If I did it before, it became a mitigating factor, actually. And then usually if they go, they will set up a treatment option. You need to try this and this and this, and that becomes part of their probation. All right, let's talk about this probation officer, one of the unsung heroes of the criminal justice system. And they really wear two hats at first. They wear an investigative hat and they wear a supervisory hat. So they are going to do investigations. They're going to do things like pre-sentence investigations, where they're going to determine what type of sentence should be imposed. Then after a sentence is imposed, they're going to take over as a supervisor. The judge is just there briefly. All right, so the judge gets the information from this probation officer. Here's his home, living conditions. Here's is he supporting his family? Is she a mother? All this information. The judge tailors a probation, and then it gets turned over, and a probation officer supervises and makes sure they live up to it. Now, in smaller agencies, a rural agency with low populations, a probation officer is going to do both those jobs. But as the agencies and caseloads and size becomes greater, they're going to usually split that. So you'll have one guy just do investigations and another girl just do supervision. Obviously, there can be role conflict here. Who does the probation officer identify with? Is he going to work for the best office of his employer, the county, the city, the state? Okay, but can that mean that he's supposed to help the person on probation, make sure they complete probation, make sure they get to their AA meetings, make sure they get to their jobs, help them find jobs? How much do they help them? How much do they protect the community, and where that line is drawn? And that's a role conflict there. The other big thing is that we have a caseload dilemma. If the American Probation and Parole Association says that if let's suppose you are a probation officer, and in a given month, we'll say, you are supposed to have X number of offenders. If we assign you 20 offenders, that's, again, remember what a saving that is. If you've got 20 offenders at $30,000 offenders, you're saving the state $600,000. Now, trust me, you're not getting paid $600,000 if you're a probation officer. Again, if you're handling 200, you're saving the state $6 million. I kind of messed this up earlier, but I'm going to redeem myself here. You're only supposed to be monitoring 20. Now, that means that, let's just say in a given week, if you've got 20 people you're watching, and let's suppose you work a 40-hour week, that means you can devote, let's just put paperwork and other things aside, you can devote 2 hours a week to monitoring someone on probation. That's not an extremely long period of time, but it would enable you to say, well, I'm going to drive out to his place of employment. I'm going to drive out to his house to make sure that he's not living with people who are criminals or selling drugs. I'm going to really be hands-on. I'm going to investigate. But as we start to raise that, as we go to 50 or as we go to 200, you'll notice that at 200 you don't have 2 hours a week, 120 minutes. You have 12 minutes a week. You have only 12 minutes per client per week. And it's not uncommon to have a caseload in North Carolina running at 60. Which again kind of puts us someplace in the middle. That gives you about 40 minutes a week to watch someone. That's not great. What it does mean is there's going to be less actual physical interaction and more interaction on things like, okay, well, I called up his employer and did it over the phone and checked, or I called him at home to see if he was home during these hours. So you can do a little bit more of that. But when some states where they get up to 200, you only have a fraction of the time really to handle this issue. Okay, let's move on from that. Revocation or completion. So there's two broad options on probation as to what can happen. The ideal one, the one that I think everybody hopes for, is that the offender, the person that's been placed on probation, can meet all his conditions, can do everything that is called for, and then the period of probation expires, and he has now completed probation. They are released. A couple things follow them. They have a criminal record that they're going to have to tell people about when they get jobs or try to enlist or do things like that. They also can have reduced rights. They might not have the right to own a firearm in some jurisdictions. They might not have the right to vote in certain jurisdictions. They might not be able to live in certain locations. If they, for example, were accused of a sex crime, they may not be allowed to live within a set distance of a school. Um, Offenders, of course, sometimes don't complete them. They can fail, and their probation is revoked. When this happens, it starts with the process of the probation officer typically saying, okay, he's not doing it, we're going to revoke his probation. And that usually means we have to have a hearing. So there's been a violation of his probation. And if it's a serious enough, like a new crime, okay, it's usually going to be done pretty quickly. There can be technical violations where typically the probation officer is going to have a little bit more discretion as to whether to go or start the revocation process. But the whole process is kind of like a mini trial. You can think of it that way. So prior to the 1960s, there weren't a lot of rights. But then in 1967, the Supreme Court began to say, well, since you're really putting people in prison, we should have some sort of due process to do this. So first they gave them the right of legal representation. That was in Memphis v. Ray, 67. Then in Morrissey in the Scapelli case, they said, okay, you're actually going to get a three-stage process for your revocation. So we're actually going to impose, like I said, kind of a quasi-trial here. So what happens? Well, the first thing that happens is we're going to revoke your probation. We bring you in front of a judge, and we have a preliminary hearing. Now, this is like the probable cause hearing that we see before trial. Is there enough information viewed in a light favorable to revoking the probation that we should revoke it? I mean, if there's no evidence, if the probation officer says, I just have a feeling he's breaking probation, it's going to get tossed here and he's going to remain on probation. It's not a high standard, though. If there's enough evidence, hey, I caught him with associated with a known criminal, okay, well, we will have a revocation hearing about it then, which is the next stage, is kind of your trial stage. In front of a judge, and it can be there are different types of judges here. It depends whether we're at federal or state level, and there's a few things. But in front of a judge, the agency, usually in the person of the probation officer, supports evidence that there was a violation of probation. And at this point, there's going to be testimony and physical evidence presented. Here's a picture of him at a bar when he shouldn't have been, drinking. Here is records of him getting arrested, and his probation doesn't allow him to commit future crimes. You're entitled to an attorney during this. The judge has to decide if there's enough serious violation to revoke it. There is no presumption of innocence here. So the standard is not proof beyond a reasonable doubt you broke your probation. It's merely a preponderance of the evidence. And this is a crude way of looking at it, but simply saying, is there more evidence he broke probation than not? Okay, does probation work? Well, I think a lot of that depends upon what you're expecting to get out of it. Probations can be evaluated depending upon what standard you use for success. Does it prevent future arrests? This is recidivism. Is that how you're going to measure it? Are you going to measure it based upon future crimes? Are you going to measure it on future serious crimes? How are you going to measure these things? So one of the things we do know is that the most effective probation are ones where we get people to change their behavior. And it's very difficult. This is that rehabilitation issue. And this goes back to what we were talking about in prison a minute ago, is rehabilitation is a very difficult thing. Changing people is incredibly hard. What we do know is that the smaller the caseloads, the more that probation officers can watch those people on probation, help those people on probation, monitor those people on probation, the lower your recidivism rates. So what are your big risk factors that people are going to break probation and go back to prison? Antisocial personality patterns, and this runs the gauntlet if we take the most extreme. Asocial personality disorders, what used to be called psychopathic, sociopathic behavior. That's a real risk factor. people that don't have that sort of filter of guilt, don't have that sort of filter of empathy, they tend to fail probation. Pro-criminal attitudes. You have people that haven't learned, people that simply have decided, they're going to keep committing crimes. Those types of people are going to fail probation. Is there social support for crime? Are they living in an environment within which whatever crime we're talking about, maybe it's something as simple as drug use or alcohol use, maybe it's something more extreme like violence towards women, are they living in a societal or group that supports that? And then there's some broader societal factors like, can they get a job? Do they have substance abuse problems? Again, if unemployment is common and it's difficult to get a job, if this person has a substance abuse problems, the probability of completing probation successfully is lower. Now, parole is a little bit different. First of all, federally, quite a while back, the federal government got rid of parole. If you get a sentence in the federal system, you get a day-for-day sentence. It's done. Probation versus parole. Parole, you serve some time in prison first. So these are going to be mainly the states are going to do this. And then we're going to let you out before your sentence is complete. So let's suppose you get a 10-year sentence. You'll serve 5, 6, 7 years. Then we will say, okay, you can go out on parole for the remainder of your sentence. And this is a mechanism, first and foremost of which is it allows us to control people in prison. It allows us to say in prison, behave, you'll get out of here sooner. Don't behave, you won't. And it's based on the concept of mercy or grace, that mercy has to play a role. I mean, mercy is part of justice. The contract of consent and custody. All of these are concepts based on parole. The difference, of course, is probation is imposed by a judge. Happens in open court. Parole is made after you go to prison. And how this is done varies from place to place. Some states have parole boards, some leave it up to special panels of people, which function much like parole boards. The North Carolina parole law. Now, for felonies, we don't have to worry too much about misdemeanors. North Carolina has the Structured Sentencing Act, which was passed in 1994, and I showed you in, I believe, the last lecture, if you're watching these sequentially, the North Carolina Structured Sentencing Grid. And what it says is offenders must first serve their minimum sentence. Now, typically, you are going to serve 85% of your sentence. So crudely, if you got 10 years and a few months, you're going to serve 8 years. At that point, there is a commission that reviews your behavior. And this commission is appointed by the governor of the state. And they meet about once a year, and they look and they will take evidence. One of the things they'll do is any victim or family member of a victim can provide information to the commission saying, yes, let him go, or not. I was fascinated that the person who assassinated Robert Kennedy, Sirhan, out in California, is up for parole in California. Now, he's been in prison since the late 1960s. So he served, 40 plus years. They have a very similar type parole board, parole commission in California. And interestingly enough, the children of Robert Kennedy have stated that they feel he has served a long enough sentence that he can be released. So, that can be very positive. If you have a victim that says he's paid the debt, I don't feel I'm owed anymore, I think parole becomes much more probable. If you have someone who says, well, he killed my only child, I can't forgive him, I don't think I don't think parole is as likely. You can look at your crime you commit, you can look at the previous record, your conduct, and any testimony in prison. So jurisdictions are going to have their own procedures for determining release dates. There are parole boards, usually with 3 to 7 members. We have 4 in North Carolina, usually, as in North Carolina, appointed by the governor. They decide who gets placed on parole. They determine the conditions of parole, much like the conditions of probation. They discharge the offender when the conditions of parole have been met or not met. And if a violation occurs, they decide whether to revoke it. Typical factors considered in parole: what did you do? The more heinous, the more violent, the more serious the crime, the less likely you get parole. What's your prior criminal record? record. The longer your criminal record, the more likely you don't get parole. If you have no criminal record, now it's more probable. What's your attitude towards the victim and the victim's family? What's your physical, mental, and emotional health? How have you behaved in prison? And of course, this goes back to what I said, how do the victims feel about this? So the parole hearing, the entire board reviews the information, meets the offender, hears the testimony, determines whether to grant it. If it is denied, you can have release. Now, some states have moved away from discretionary release. They've gotten rid of a lot of their parole boards. They simply say you serve your sentence minus good time adjustments. Offenders usually know their presumptive parole dates when they enter prison, and we have parole guidelines. So again, I think there's been this struggle in the criminal justice system about we are afraid that discretion gives rise to prejudice. So we've been trying to eliminate discretion, but as I said, you don't ever eliminate discretion, you move it from one location to another. The conditions are very similar to probation. You're going to have a contract, and you're going to agree to behave in certain ways and have limited rights, like you can't own a firearm, you can't associate with known criminals. All these are very common. If you commit a crime on probation, or on parole, it's going to get revoked. Again, if there is a technical violation, if you don't, within the set period of time you're supposed to when you change address, let your parole officer know, there might be a little bit more discretion. It may not be a formal revocation. Okay, probation and parole. Let's talk some about the intermediate sanctions, some other things that can come up. Now, many feel that imprisonment and probation, their cousin parole, fail to reflect the diversity of crimes, things that happened. So maybe we need more restrictive, or maybe we need less restrictive alternatives than imprisonment. So what do we have? Well, we have things like fines, community service, restitution, forfeiture, and pretrial diversion. Quickly looking at those. Fines is kind of self-explanatory. A fine is saying you're going to pay X amount of money. Now, there's some contention here, because if you think about it, if you say the penalty for a fine is money, in some way, not absolutely, but in some way, this is discriminatory against people that don't have money. If I make $1 million and Bill Gates makes $1 billion and John Doe makes $1,000, and there is a fine of $10,000, I can probably pay it. Bill Gates can definitely pay it. The poor guy cannot pay it. Community service, self-explanatory again what it is, can be something as simple as picking up trash. Restitution, this is a very common one, where you say, okay, you stole X amount of money from somebody, or you stole some property. We're going to look much more favorably on a lighter sentence if you make good, if you pay them back. Forfeiture, this is pretty common, particularly for certain drug offenses, where they say, oh, you used your car in transporting drugs across state line, we're going to seize the car. And then pretrial diversion programs, I talked a little bit about this, is getting people out of the system altogether, finding an alternative. So pretrial diversions are alternatives. Where do you see those most of the time? You see most of those in juvenile cases. Sometimes you have a kid who messes up, and they come to a judge and the attorneys, and they say, this is not a bad kid. We don't necessarily want to saddle him with a criminal record for the rest of his life, and he never gets in the military or never gets into college. So let's divert him. Let's find an alternative where that if he completes some counseling and treatment and makes restitution, the charges are dropped. That's a pretty common one, particularly for juveniles, first-time offenders. Problem-solving courts. Now, these can address very specific problems, sometimes very specific groups of people. So you can address problems like drug addiction, mental illness, domestic violence, but you also could focus on, there's things called veterans courts, where the trauma of war has, reshaped people's personalities, and they need help. So you might say, we're going to have a veterans court if you have someone accused, say, of assault, and that his his or her action can be traced back to some trauma she suffered in war, we're going to handle that differently. Forfeiture. This is a process by which the government seizes property. Now, there have been billions and billions, as Carl Sagan used to say, billions and billions of dollars seized by the government. Now, the interesting thing about forfeiture is often, first of all, the money that's seized goes to law enforcement to use in fighting crimes. Sometimes, rarely awarded to third parties. We have some provisions in North Carolina that some seized property actually goes to school districts. But in some states like Louisiana, when property is seized by the police, the money goes to the police. Now, that creates kind of a weird incentive. Also, you don't have to be convicted of a crime for forfeiture, because sometimes this is a civil matter where we think you were transporting money to buy drugs, so we seize the money, and you have to prove that you weren't. There are day reporting centers, self-explanatory is what that is. There are intensive probation supervision, more restrictive alternatives. So we want you, for example, sometimes living places. We want to give more control of the individual, maybe because they're not quite bad enough that we want to send them to the big house, but they're not quite as blameless that we want to let them on the streets under just regular supervision. Shock incarceration I've talked about. The home and confinement we're aware of, I think, where you're required to be really confined to your home. And sometimes we do electronic monitoring. And there's all types of different electronic monitoring. There are the famous ankle bracelets. There is a system where you call it. There's randomized calls that you have to answer at certain times. Again, the good thing about these is they're remarkably cheap compared to a prison. Home monitoring can be a curfew or detention or incarceration or monitoring, all pretty common, again, because if it's $30,000 to keep someone in jail, a monitoring system might be $1,000. So you can have 30 times as many people being monitored. One of the last things, and I had introduced this concept at the beginning, is net widening. And this is one of the criticisms of intermediate sanctions. If you said that the only punishment for crime was prison, if you said if someone's convicted, everybody goes to prison, so you're really eliminating all discretion there, you're going to have a set number of jail cells, right? You're going to have, say, 1,000 jail cells. That means you're going to have to prioritize. You're going to have to say this crime is bad enough to warrant jail. Even if someone commits this other crime, there's no room in the jail, so we can't go forward. What probation does is, since it allows you to bring a lot more people into the system, it allows you to punish more crimes. Because there are more and more alternatives to actual incarceration, there can be more and more people in the system. Now, we can also talk about strengthening the net, such as widening it. What do we do? Well, we can increase the government's powers to intervene in citizens' lives. We can allow technology to advance this. For example, we could monitor people, as opposed to ankle bracelets, cell phones. I'm sure you could write an app that would say something like, every time someone on probation gets near a given cell tower location that's near a church or a school, we would be made aware of it. Okay, so there's a bit of a paradox here. The ability to monitor those and release is increased by technology, but that also means that more violations are going to get detected and more revocations. So maybe we need to think about less reincarceration for technical violations, at least from a cost-saving perspective. All right, on that note, we're at about 45 minutes or so. Whenever you're ready, you can go on to the next chapter. We're going to start delving into prisons and jails. Have a good day otherwise, or good afternoon or good evening.